106 Fields versus Fields. Counsel, do you want any rebuttal time?
I'd like about 4 minutes. For
4 minutes, go ahead.
May it please the Court, I quite frankly am at a loss to understand the rationale behind the majority court below, because what we had here is admittedly a gift which my client had received from his grandfather.
Yeah, but there is a presumption, isn't there, that this is, was acquired after the marriage? Doesn't that make a difference? For starters, put you in a
Not if
different
it's separate
posture?
property, however, that he received.
What about the Citibank account?
I'm sorry.
What about the Citibank account? Wasn't there some issue as to whether or not
There's
marital...
no issue whatsoever with respect to the Citibank account, because the only joint account that the parties had was an amalgamated bank account.
But it was admitted that but her money occasionally did go into the Citibank account.
It's a different Citibank account at all. This Citibank account where this $30,000 was deposited came right out.
Oh, okay.
And went to buy the property.
I'm sorry. You're still talking about the townhouse.
Yeah.
There's
We're
another.
not talking about
Okay,
that,
go ahead.
that other account.
Didn't your client get a credit for that $30,000?
Well,
Didn't the court find it was marital
you'd
property
get-
minus $30,000?
You would get you'd be entitled to a back-out credit if you created a marital asset. If I bought a house in the name of my wife and myself, and I put
title doesn't-
$30,000 of my own separate property that I had before I was married, or property that was a gift that was given to me, and I put the piece of property into both our names.
It doesn't
and now
make
our
any
marriage
difference.
breaks up, the court would back that out for me.
Yeah, but it doesn't make any difference in title, in whose name title exists.
Well, to that extent, but the point is, Your Honor, that we start off here with separate property. And the statutory principle is a separate property follows separate property. And this
But
separate property...
if she were responsible for the appreciation, then she would be entitled to share.
If there was some appreciation,
Yes, it
then
isn't-
she would have a right within the appreciation. And...
Well, there's been some appreciation. I mean, the townhouse is worth more than it used to be.
Well, the only thing is, you have to show that there was a nexus, back to that word nexus. There has to be a nexus between
You have to
something that she did to cause the appreciation.
And our cases have been somewhat indulgent in finding that kind of relationship, haven't they?
The only thing is, if we really look at what this lady did in the analysis, and this is what the dissenting court found, and I do agree with the dissenting court, and I have the analysis in my brief. What she did really was absolutely nothing. It didn't add 1 penny in value to
Didn't
that
she act
house.
like a super? I mean, she swept clean dog excrement from the front of the property, swept the building's sidewalks, sweeping and bagging the leaves each year, etc., washing the lobby curtains, cleaning the lobby windows, polishing the lobby mirror. Wasn't that like superintendent services?
This woman indicated specifically that the only reason that she vacuumed that area was because she wanted it clean for herself. She never did anything above that first floor. She never did anything for the second floor. She never vacuumed steps. She never cleaned
If
the
this,
third
if this,
floor.
if this was a single-family residence, and you had a couple like this couple that was married for, 8 years, and then they finally buy a single-family home, and the wife doesn't have employment outside the house, she's a homemaker, how is that much different from this situation?
That's completely different in the following respects. If the lady is a homemaker at home, she is entitled to receive something for the fact that she's a homemaker. She is entitled if her being a homemaker is adding to the increment
suppose
of the
she were.
property.
A
But if
lot of
she-
married couples keep separate bedrooms. Is that different from this
Well, there's
couple
more
having
than that.
separate
There
apartments?
was more than that in here, Your Honor. This is a woman who went off on her own. There was no real economic
Suppose,
marriage in here.
Well,
She separated herself for 28 years.
I think we're talking about separate things. Suppose you had that, but you also had Judge Graffio's single-family home, and a wife who is doing she's not a homemaker. She's not. Let's say they have no kids, to simplify it. She doesn't contribute anything as a homemaker. All she does is she works around the house and she keeps up the house. Does she get any credit for the appreciation of the house?
No, if this house was separate property of the husband, admittedly separate property of the husband,
Even though she worked in it?
and she's around the house, and she doesn't add 1 penny toward the appreciation of the value, which is all passive.
Isn't the question whether there's support in the record for the finding that she did add a penny or two?
It's a question of whether the increase is passive or active. If
That
it's
seems rather
passive, she's not
contrary.
entitled to any part of it.
That seems rather contrary to the whole purpose of equitable distribution and eliminating title as
But
as
Your Honor,
determinative of what the woman's contribution is.
Your Honor, my understanding of the majority is, irrespective of the fact that this piece of property was purchased with separate property and maintained with the proceeds of the separate property, irrespective of that fact, they say because it was purchased during the time that the parties were married, this became marital property.
How is this different from, I want my daughter to have a good home, and she's married to someone who doesn't make a lot of money, so I want to give her money to buy a house. How is that different? Or my son, I want to give him money to buy a house, so
You're
he's-
giving the gift to
And
him.
that's a gift,
You're-
because I want him to
If
be
you're
happy.
giving it to him only as a gift, we have plenty cases,
But
Your Honor,
it's for the
that say
purposes of raising a family and providing
the
a home.
cases are legion, that if you gave it to your son alone, and the title is in the name of your son alone, you gave the gift to your son alone, never intending any part of that gift to go to your daughter-in-law, that is separate property of your son, and it is never transmuted into marital property.
Never
And
unless
that's the point.
the
There's
daughter-in-law
never a
contributed to the
transmutation.
appreciation.
Excuse me?
Never unless the daughter-in-law contributed to the appreciation.
Now, if she contributes to the appreciation, it's a different story. It's still separate property, but now we have the appreciation as separate property, and the statute says that the appreciation is marital property. That's different than the ownership situation.
Well, so let's say
And
that-
within the appreciation, if she contributed to that appreciation, then, of course, she's entitled to a part of it. However,
So let's say.
now we have to determine that which she did. Did it contribute to appreciation? Now, what did she actually do?
What would she have to do?
What would she have to do?
Yeah, the normal keeping up of the house doesn't contribute.
Well, she didn't do normal keeping up of the house. That's the point.
What if she were,
She
what if
did
she
for
were very
herself.
handy? What if
Excuse
she
me?
were very handy and she remodeled 2 or 3 bathrooms?
If she were handy and remodeled 2 or 3 bathrooms, that house would be enhanced in value by the fact that it had new bathrooms. She'd be entitled to a piece of that appreciation. But what did she do?
So you've got to
The-
keep,
the
you've got to
expert-
keep
the
records,
expert
you've got to keep records over the course of a long marriage, every year of what you did at
Under
the house.
Hartog, Your Honor, you don't have to keep a record, but you have to show a nexus. There has to be something. The expert testified that the appreciation of this building did not appreciate by anything that what she did.
Mr. Davis, didn't even the dissent come to the conclusion that, I want to go back to the Citibank account, that was marital property?
That's a different account. That was a partnership account.
Right, but it did, if
That was
I...
not the account that was used to buy the building. That was a completely different account.
But that account, as I understand it, I was looking at Record 108, the funds were commingled with marital property, and I think even your client called it a mishmash, and that was an account to maintain the rents and the mortgage funds obtained by the partnership.
No, it wasn't to maintain the mortgage funds. What was deposited in that account? What was deposited in that account were rents received, which would be the proceeds of the separate property, and the marital portion that went into there was that he had deposited a certain of his checks into that account.
So there's
So that what he did was they found, although I don't agree with it, for what I have in my brief, but I can see why they did what they did.
She deposit, her rent that she paid on her unit, was that deposited into that account also?
She didn't deposit into that account. What she did was she gave him X dollars because she wanted transfer funds. And so there was she would give him dollars and he would have a check out, or she would give him dollars and he would have a
how she paid
wire
her rent?
transfer for her benefit. But she wasn't depositing funds, she wasn't parking funds in that account.
How did she pay her rent?
She didn't pay rent. She didn't pay rent.
These parties did raise children in this building, didn't they?
There was one little boy.
Well, we
that
have
little
we have
boy-
recognized child rearing.
That little boy, Your Honor, the mother taught all day long. The mother worked all night long. When the little boy was up to the time that they bought the house, she raised the little boy at that time. They raised it equally, in fact. They raised it together. Now, after that, when the mother separated herself physically from the father, that little boy slept down with the father in the basement apartment. He wasn't sleeping with the little boy, with the mother. The mother did not raise that child any more than the father raised the child. And that is very clear from the record. But what she did, and this is the problem, there was no real economic family in here. The economy of it was such that what I made went into my pocket and it stayed there. She admitted
Well, a lot of
never paid rent,
couples
she
live
never
that
paid
way.
utilities.
A lot of couples live that way. We don't necessarily get into how people arrange the economics
Well,
between themselves.
accepting there are cases, and I cited several cases in my brief, where the court does take into consideration the fact where the party actually is not it's not an economic partnership. This is not an economic partnership. She has divorced herself basically from the building.
Your posture is she's just a
If
tenant.
somebody wanted to collect rent or give rent, she wouldn't even take the rent. She did not give of her time to permit her husband to give of his time to work the house. He worked, she worked, he took his time off, she kept working.
What's the
She put the money in her pocket.
Counsel, so what's the relationship between the two of them?
The relationship, they were husband and wife, period.
In name only?
In name basically
and
only for
what-
some 28 years.
Living together for all those years.
They weren't really living together, that's the point.
Well, what is the relationship? They had no relationship?
They had no relationship. She kept herself separately. A room had originally they started in a duplex apartment, a basement and an apartment above it. Incidentally, the construction of that apartment was all paid for by my client's mother. He never put another penny into that house.
Mr. Davis, wouldn't
besides
it be stronger, correct me if I'm wrong, wouldn't it be stronger if she did pay rent? I mean, wouldn't that indicate more that she was merely a tenant rather than part of the management, so to speak?
Yes. She moved
you were the one that argued that she didn't pay
She
rent.
moved into a second-floor apartment because she didn't want to sleep in the basement. She claimed that it
I
affected her
thought I
sinuses.
saw some testimony that she did pay rent
Yes,
for that.
and when she went into that apartment, she testified that she offered to pay rent for that apartment. So while she was in that apartment, she paid rent. Then what happened? An apartment empties out on the second, on the main floor, a second apartment. There are two apartments on the floor. The duplex was on one side of the main floor, and another apartment empties on the other side of the main floor. She goes into that apartment. She puts a lock on that door. My client has no access to that apartment. She moves her things into that apartment, and she squats in that apartment right up until the time that the marriage ended. Actually squatted in that apartment. And she separated herself completely.
And you're saying she paid no rent all those years?
No.
And then did the husband make a claim for that?
He was a nice guy.
With this person who we had no relationship with?
No relationship. Occasionally they had some meals, but that's about it.
Okay, thank you.
Thank you, Your Honor.
May it please the Court, my name is Elliot Polland, and I represent Lucille Fields.
And this is marital property. We're talking about the half interest that the husband owns in this property you claim is marital property.
Absolutely,
That's what the courts below
and let me
claim.
explain why.
100% of it.
100%
Other
of
than
that.
the $30,000, and in fact, we actually...
100% of the appreciation is marital.
100% of the entire property, let me rephrase that, 100% of his half interest in the entire property, because the property is owned jointly between Mr. Fields and his mother. So his half of the property, less the $30,000, which is what the special referee, Judge Silberman, as well as the appellate division concluded. Now, the argument
Is
of
it
my
really
adversary...
credible that a townhouse in Manhattan appreciated from what was $130,000 to $1 million and change, and all that she contributed to all that? The market didn't have something to do with it?
Absolutely, the market had something to do with it.
Well, why should she get a share
Because
in
the
the
bottom
market?
line is, this asset was never separate property. And there are myriads of cases that have come through our court system where somebody either had money in advance or received a gift, or as one of the judges has suggested, or an inheritance, and they put part of the money in. But let's
Well, why?
recognize...
It was never separate property. Why did he get his $30,000 back?
Because that's the separate property. That was his contribution. And we have cases like Bartha, we have cases like Murphy.
What was her contribution?
She did not contribute economically.
Well, if the whole purchase price was separate property, doesn't the apartment start out as separate property?
No, because the whole, and that's exactly what I was trying to say before. I didn't have a chance to complete my sentence. This property was bought for $130,000. $30,000 was this, quote, separate property, and $100,000 was financed, paid by a mortgage. And where did the mortgage money come from? The testimony of Mr. Fields was that he paid $1,100 per month in rent, which he paid from marital funds, his earnings, extending from September of 1978, a few days after the house was bought, up through 2001. I actually did a calculation as to what that equaled, and it came out to over $300,000 of marital monies that he utilized to pay the rents.
You say the apartment was a marital asset from the start.
Correct.
Why
Other than the
is it-
$30,000 gift.
But then, I mean, if I put $30,000 of my separate money into a marital asset, is it the law that I get it back at the end of the marriage?
Yes, and that's what I started to say a moment ago. They have the Murphy case, the Maxek case, the Bartha case, the Zelnick case. All of those cases basically say that you get the exact dollars back. In fact, in two of those cases, one of the parties, the party who had the separate property funds, said, well, how about if I get a percentage? If I put up 20% of the original price, shouldn't I get 20% on the back end?
So
And the courts have consistently said, absolutely not.
So
you get your dollars back.
So your view of this case is this is not an appreciation of separate property case at all?
And that's exactly what the appellate division, as well as the other judges said.
I understand that. Make the other assumption for a moment. Assume that the apartment was separate property. I understand your argument that it was marital.
Well, you know,
If it was separate property, does she get the is the appreciation marital?
She contributed, well, first of all, if it was separate property, both Mr. Fields clearly did work during the course of the marriage related to this.
Before you explain, what's the answer? You say even if it's separate property, the appreciation is marital?
That's correct, because she contributed, and while my...
All the appreciation?
There was no distinction in the record as to what appreciation was attributed to.
Is there a basis for finding that most or all of the appreciation was active? I mean, isn't it obvious that most of the appreciation had to be market?
There was no testimony one way or another that quantified how the appreciation
Well,
accrued.
there was an expert who testified that the main factor was the market, and the second most important factor was renovations that the mother did.
No, actually, the renovations also occurred by the husband. There were constant renovations, and in fact, the findings of the special referee were that when the house was refinanced, the money was used to replace the boiler, the roof, lighting, and there was one other factor, which if I can find it for a moment, so that the monies that were utilized on the refinances were utilized for the improvement of the house. This is not a situation where $30,000 suddenly escalated into $2 million. This is a situation where there was a constant renovation of the house, including the renovation of the apartment that the parties occupied. And then the testimony of Mr. Fields was clear that from time to time, as an apartment became available, it was renovated. So it's not merely the mother's apartment that was the renovation, but there were multiple apartments done in the building that were renovated.
Who paid for the renovations?
With regard to, the answer is that the bulk of the renovations came from the mortgage refinancing. The mother paid for the renovations on her own apartment. The renovations on the Fields apartment in the basement and the first floor were relatively nominal. But all of the other renovations came from the working capital from being an operation. What I think the problem here is that if these parties resided in Queens County, the likelihood is they wouldn't have been buying a townhouse, they would have gotten a two-family house. And the cases are very clear that in a situation like that, all the husband would have gotten back was his initial investment. And the fact that it was a townhouse that had extra tenants, because over time, townhouses that originally were probably a one-family home evolved into these multiple residences, doesn't change the situation at all. The bottom line here is, and this is where the majority disagreed with the minority at the appellate division. The minority said this is a business enterprise. This wasn't a business enterprise. This was a home for the parties. And it was a home for the parties that had some additional rent to help pay for the carrying
Did she
costs.
pay rent?
She did pay rent.
Doesn't that militate in favor of the husband?
No, it doesn't at all. What happened was that
My wife doesn't pay me rent.
and the
I'm not
husband.
complaining, I'm just using it as an example.
The fact of the matter was that when the parties were residing in the same three apartments that were part of the, quote, their unit, there was no rent charged. Then when my client said, I can't live in the basement, my sinusitis is affecting me, the husband said, well, if you're going to move into this next floor apartment and you're taking money out of the pot, so to speak, then I want you to pay rent. And she paid the rent for a period of time, and then ultimately she moved into a different apartment and didn't pay rent any longer.
Do you claim that she contributed as homemaker and parent to the appreciation?
Absolutely. The testimony was that she paid for multiple things related to the child, including his tutoring, his food, his clothing, his private schooling, and that all of these basically freed up money that the husband otherwise would have had to pay to support his family.
The more typical homemaker and parent situation is she took care of the kids, she kept up the house, she entertained the business associates, she kept him happy. You don't really have that here.
Well, we certainly do, to a certain extent. I mean, the reality is...
They were living in different dwellings.
Well, you know, they were living in different dwellings, but, you know, most people who are married for 30-some-odd years, and if it was terrible from year 2, don't remain in the remaining 26 years or 28 years. They usually throw the gauntlet down.
But some of those people, even if they live in the same house, they don't always have a division where one is the parent homemaker and the other is the earner. And wasn't this a couple where they were both equally earners and parent homemakers?
That's correct. So that doesn't, by virtue of that, that doesn't mean that she didn't participate as a parent, a homemaker, and do all of the other
Well,
rights and
so listen,
functions.
when you have that situation where both parties are equally parent homemakers, and one of them is spending full time on a business, which becomes on property titled in his or her own name, which becomes very profitable, what's the claim of the other to that property?
Because the answer is the title, as was indicated a moment ago, is irrelevant.
Okay.
The only thing that's
Okay,
relevant
so
in this case is that Mr. Fields took $30,000 of separate property against $130,000 and then ultimately, by virtue of paying rent that came out of earnings,
Well, if the building's separate property to begin with, then the rents are separate property too, right?
if the building was, well, the first question is, was the building his separate property, or was only a small portion of it? And if that were the case, then how come in all of the other cases that have been decided by our courts, do they simply say you get back the $20,000, $30,000, $40,000 separate property on the dissolution of the marriage?
I guess you're saying essentially the down payment portion was separate and the mortgage portion was marital.
Absolutely.
So let's say it's 1 to 3, although it isn't. Let's just
It turned out to be about 23%.
Oh, okay.
I did the math
good.
on it.
It's 23%. It starts out 23% separate. Are you saying that as it appreciates, the marital all the appreciation gets allocated to the marital part?
And that's exactly what the case law says.
What
All the
case
case
is
law
that?
says is you get your separate property back. You do not get the percentage and extrapolate the 23%
Which
to the
case
$2
is that?
million investment.
Which case is that says that?
One case is Bartha, B-A-R-T-H-A at 1583rd, 311. The other case is Heine, H-E-I-N-E, at 176 A.D. 2nd, 77. In fact, in the Heine case, and I happen to have downloaded it, it specifically says transmuting the contribution into a percentage and applying that percentage to the appreciated asset constitutes manifest error.
Well, but
Bartha essentially says the same thing.
in Heine, they had a very strong case that the wife was responsible for the appreciation, didn't they?
The wife clearly did some contributions, absolutely, but the issue is not the contributions. What I thought we were talking about was the percentage issue and whether or not the percentage should be applied.
Excuse me. As I understand it, you're stating it as a rule of law that if you've got an asset that's, to simplify, half marital and half separate, and it quintuples in value, regardless of whether the non-title, whether the one spouse contributed to the appreciation or not, then all the appreciation goes into the marital category.
That's what the case law says. But in addition to that, we don't accept the proposition that my client made no contributions to the property.
I understand.
And the record, and as well as the appellate court, repeats extensively the contributions she made. The fact that they may not have had a specific economic value doesn't in any way diminish the contributions.
Well, the court made some adjustment anyway, because she didn't get 50% of the marital assets, she got 35%
Exactly.
of the marital assets,
And what the
right?
court basically said is that given that the husband's contributions were larger than the wife's, instead of giving a 50-50, which would be somewhat more normal in a marriage of 30 years, they reduced her percentage to 35, in effect giving the husband 65% of that.
I understand what you're saying, but isn't that the wrong way to do it? Aren't you supposed to first figure out the extent to which she gets, which the appreciation is marital or the asset itself is marital, and then decide what the right split is?
The answer is that this asset was acquired during the marriage. It was purchased 8 years after the marriage. There's a presumption it is marital. The only portion that was not marital was the $30,000 contribution, which the court backed out and returned to Mr. Fields. So the answer is, in my opinion, that the court below did what was exactly required under the law.
But in principle, you agree that that the right way to do it, as our case has said, is first you figure out what's marital and what's not marital, and then you figure out whether you're going to do it 50-50, 65-35.
Yes, and the court concluded that the house was marital but for the contribution which they returned to Mr. Fields. And if the
And that's
court
what he's appealing from.
Understood. And as I said before, the case is a legion on this very point. And if there is no further questions from the court, I rest on my brief.
Okay, counsel.
May it please the court.
Go ahead, counsel.
We have a presumption, but we also have the cases that say irrespective of the presumption, we also understand the concept of separate property. And the name of the game is called tracing. And if you can trace it out, it's yours. We started with separate property, we traced it out. So now it becomes a situation of increment, and what is the increment that this lady contributed to the house? Now, I understand that at the appellate division, a question had been asked. I wasn't there, I was arguing on Rosh Hashanah, but I was told back. Supposing this was Mrs. Trump, and Trump bought a building with 50 houses, 50 apartments in it, and they take an apartment for themselves. Does that mean that because they took the apartment for themselves, that the entire building became marital? This is as simple as this is only 10 apartments.
Mrs. Trump may not spend a lot of time bagging up the garbage.
She only bagged the garbage, incidentally, once. The court, the referee went way afield. There was one time when my client was in France, and we had somebody to do the garbage, and she didn't like the way he did it, so she fired him.
Actually, the referee
and that
found
one
that-
year, that 1 year, she bagged it.
As I read it, the referee found that both ways. Once he said one summer, and then at another point in the opinion he says every summer.
Yeah, it was all over the place. There were a lot of findings by the referee, really, which didn't have the impact that the referee gave or should have given to it. Now,
Regardless of what the referee did, isn't the rule that if one party has a business, let's say a law practice, O'Brien, if one party has a business, that the spouse is entitled to a piece of that business if they've contributed
if she
even
did, but she
passively?
didn't contribute. In fact, the expert, the real estate expert did testify specifically that the lion's share of the increment in this house was passive. In fact, I believe I did numbers, and the numbers I did in my brief said that I assumed that anything that was done active was done within the first 25 years of the house. And the expert used numbers on it. It was a tremendous jump in the market. And I found a figure that maximum would be $800,000. Everything after that was 100% passive due to market activity, having nothing to do with anybody contributing to it.
Bottom line, what are you saying, what percentage does she receive?
Excuse me? I didn't
But the bottom line here, what are you proposing that she receives in
Quite
terms of
frankly,
the residence? Zero?
I propose the same thing, that's right, zero. Because
After 30
I
years,
believe that
zero.
what she did was zero, that she did nothing to even help her husband in running this house.
What about your adversary's argument that marital funds in the form of his salary went to pay down the mortgage? Is that correct?
Not necessarily, no. He paid rent for his apartment. He paid rent. So maybe if we want to take it, you want to have marital, take 1/10 of the apartment and make it a marital asset. If that's so, I had numbers also. I believe it was in my appellate division brief. But the numbers on that are no place near what she has here. But they did see the entire house was not a marital asset by no means. It was a business deal. And the mother moved in when the other tenants moved out, and they cleared out a certain area, and the mother came in. I see I have the red light,
Okay,
so I'm not going to take
thank you.
advantage of the court.
Appreciate
Thank you
it.
very much for your time.
Thank you.